Good afternoon, everyone. This is Swati Agarwal. Along with me, I have my co-moderator, Mr. Sandeep Gupta. It's our pleasure to welcome you all for our webinar on recent landmark judgment under indirect tax laws. To present the current webinar, we have our speakers, Mr. Shammi Kapoor and Ms. Kavita Jha. Mr. Shammi Kapoor is a senior partner. He heads indirect tax practice of Vaish Associates. He's been associated with the firm since long. He has vast experience of handling indirect tax advisory. Our second speaker, Ms. Kavita Jha. She is also a senior partner in the firm. She is a senior member of direct tax litigation practice as well. She is an advocate on record. She is standing counsel for Delhi High Court. And she also has a vast experience of handling litigation matters, both direct tax and indirect tax. Now, I would request Mr. Kapoor to proceed.
Thank you, Swati, for introduction. First of all, let me welcome all my friends who have joined in at this point of time for the webinar that in the next 1 hour, we propose to take you through the various judicial pronouncements that have come through by the Supreme Court and also High Court. Notably, some of them have been argued by the firm, and therefore it is quite interesting for us also to take you through the nitty-gritties of the judgment and what has been held by by Supreme Court. It is quite notably to note that this time, after a long decade, we have got a split judgment from Supreme Court in a tax matter. Normally, we see that in tax matters, there's either 2:1 or the division bench deciding the matter either in favor or against the assessee. But in one of the matters that was argued at length by the firm, including me and my colleague Kavita Jha, there's a split judgment. And during the course of this 1 hour webinar, we shall definitely take you through the various aspects that have been dealt and which, according to us, have a wide implication to various industries at large. Along with this, the other judgments that we would like to take you through is Delhi High Court recent judgment in the case of Nanuram Goyal versus Commissioner of GST, which also has a wide bearing, which apart from discussing the aspect of call book and the necessity whether the department has any legal right to file the matters in the call book or register the matters in a call book, also has held that undue hardship is being faced by many assessees at large, and justice delayed is justice denied. That is what the motto of that judgment is. Apart from these two judgments, there is the judgment of International Travel House Limited, which was also argued by the firm on the aspect of whether mere right to use can tantamount to as transfer of right to use and therefore taxable under the category of deemed sale under the provisions of VAT Act. These matters are still live at various high court level and therefore has quite importance to many of the companies at large. The other two matters which we are going to deal with recently, before retiring, Honorable Justice Joseph had, passed a judgment in respect of warranties in the case of Tata Motors versus Deputy Commissioner of Commercial Taxes, which also has a bearing in GST, and therefore we thought it proper to take that judgment also as part of this webinar. And the final judgment that we would like to take you through to all our participants who have joined in is the judgment of Honorable Supreme Court, again in the case of Ecom Coffee Gill, which also has importance because there they talk about onus of proof. And as per the judgment, if you really get into the nitty-gritty, then it's quite onerous upon the assessees at large that they would like to have the records straight. Basically, that judgment also takes care in some way with respect to fake invoicing and other aspect. Though onus now has been cast upon the assessee or the dealer who would be taking input tax credit claim. With these remarks, I would start with the judgment of Delhi High Court, in the case of Nanuram Goel versus Commissioner of GST, which was recently, delivered by Honorable Justice Bakru and Justice Amit Mahajan. That judgment has significance in having twofold significance. One, in respect of the aspect of call book, though I must point out to my participants here that the issue relating to call book is already sub judice before Honorable Supreme Court. But having said that, the Delhi High Court came out heavily upon the department with respect to keeping the matters pending in call book for long, even though adjudication or show cause notice was issued almost 15 years back. So this judgment otherwise has significance from the aspect that even though there is a time period prescribed under various acts, say 6 months to 1 year to 1.5 years, depending upon whether there's a fraud, willful misstatement, and others. Still, the department sits pretty on the show cause notices issued. So I will just take you through the facts of the case. In Nanuram Goel, a show cause notice was issued in 2009, which was duly replied to by the SSE in 2010. And then after, according to the SSE, since no notice was received, he was of the view that the matter has been adjudicated upon, though no order was received. However, after almost a good 13 years, a fresh show cause notice was issued asking the SSE to appear before them, citing that since a show cause notice was issued in 2009 and the matter was put in a call book, and thereafter now it has been reviewed by the committee of commissioners, and therefore this matter show cause notice has been revisited and the show cause notice has been issued. Having said that, the High Court, after going through various judicial pronouncements from Gujarat High Court, from Bombay High Court, and even in Delhi High Court in the case of Sundar System, had held that justice delayed is justice denied in the manner that there has to be some kind of a time frame for adjudication. It cannot be a case that you are in a deep slumber and out of when you wake up of a deep slumber, then you start issuing show cause notice left, right, and center. And in that perspective, this judgment has importance to various industry at large. And even just to add, in fact, we were doing some other matters very recently relatable to notices issued on the same aspect by DRI. Uh, just to give a brief background with respect to DRI aspect, the DRI aspect, in 2009, notices were issued after a search which was conducted upon many of the SSEs in relation to some transaction which happened between India and Russia. A search happened in 2006. 2009, there was a notice which was issued. It was duly replied to by the SSEs at large in 2010, 11, 12, even asking for relied upon documents. The department was just sitting pretty on it. And then one fine day, they said the matter was kept in a call book without even intimating the client's SSE that the matters are in call book. They were sitting pretty on it. Then after a lapse of almost again 12, 13 years, after the judgment pronounced in Canon India, where, though the issue was dealt whether DRI is a proper officer or not, even though that matter is also sub judice before Supreme Court in a review petition filed by the department, challenging the order of Supreme Court itself, wherein Supreme Court categorically held that after going through the various provisions of the Act, DRI cannot be held to be a proper officer. Having said that, there was an amendment which was carried out in 2022 on 31st March by the Finance Ministry, wherein Commissioner Customs was given the charge of adjudicating all the matters. And also they brought out a validation act. That validation act made a retrospective amendment. If all my friends know that in 2016 there was a categorically announcement by Arun Jaitley that irrespective of whatever may happen post Vodafone case, no retrospective amendment would be brought forth by their government. Having said that, they have gone, they decided to bring a retrospective amendment by validating the act and making DRI as a proper officer, though that matter, even though it is sub judice before Honorable Supreme Court by way of a review petition. The fact, what I'm trying to say here is that whatever you may say, the government is trying to revert or make a retrospective amendment and make assess. There's a harassment which is being carried out by these assessing authorities. And but having said that, when you go to the writ courts are coming out heavily. And this is a classic case of Nanuram Goyal. Though there are other judgments of ATF rate and uh, Shiv Vinayak, Siddhi Vinayak judgment from Mumbai, Gujarat High Court, Telangana High Court, Madras High Court, that you have to have a time frame. You can't sleep over it and then one fine day get up and then issue a revised show cause notice and harass a the assessee. And so this judgment, my friends can go through. This judgment has a vast implication with respect to various matters wherein show cause notice issued earlier and then a revised show cause notice was issued after a lapse of almost 10 to 12 years. This is one aspect that we wanted to deal. The other judgment is in relation to KBT. I would request my learned friend, my Kavita, to take us through this judgment so that we all learn with respect to what has been dealt by Honorable Justice M.R. Shah, which was given a negative judgment, and Honorable Justice Krishan Murari was given a positive judgment. Having said that, the matter will be referred to a larger bench by Honorable Chief Justice when the vacations open. But as on date, this judgment, though positive plus negative, has also quite significance, and therefore we thought it proper to bring it to our audience and participants. Over to my friend.
Thank you. Thank you so much. Thank you, Swati, for introducing me. Thank you, Mr. Kapoor, and a very good afternoon to all. So before I actually start with KBT, I want to supplement the judgment, the decision of Nanuram, because this will have a wide implication, not only on matters like CGST, where the issues are still, it's still open. So two points which Mr. Kapoor has dealt with. He has dealt with call book. So this is one point wherein every day when you are there before the court, the questions which are being put to the revenue councils, is the procedure of call book per se valid procedure? So of course, he has already said that this decision is pending. Whether the procedure per se, of course, there is a CBSE circular which says that the procedure of keeping the matter pending in a call book for awaiting a decision in another matter it can be done, but that is as per the circular, but no statute mandates. So procedure per se, whether it is valid or not, it is being subject matter of dispute before Supreme Court in the case of Siddhi Vinayak, and they will virtually decide is the procedure correct or not. But we have similar procedure provisions even in the Customs Act. Section 29 clause 8 is also there, and CGST Act, which we're dealing with, Nanuram 73(4). So one question which is very important, like for example, in these two cases, we just learned on the facts that the notices were issued long back in the year 2009. Then as per the procedure, the SSCs have responded, have filed replies, everything was done. Then suddenly after 10 years, now they get another revival notice. For example, they've been asked to come for a personal hearing. So revenue now wants to revive almost 10 years, 12 years, 13 years, 15 years old proceedings on the pretext that your matter was sent to call book. Sometimes the SSCs are informed after 10 years. Sometimes the SSCs are not informed at all. So the question is whether this procedure of revival of show cause notice after almost 10 years, 12 years, 15 years is valid or not. Two questions comes here. Under the Customs Act and under the CGST Act, the sections, now there are specific sections which say that you have to complete the adjudication proceedings within a period of 6 months or 1 year, depending on the allegation in the show cause notice. But prior to this, like 2014 or 2018 amendment, there was no period. The section says wherever it is possible. Now the question is wherever it is possible would mean what? So the courts have interpreted that wherever it is possible, it would mean that it should be within a reasonable period of time. So we have cases from various courts which says that wherever it is possible, you have to interpret it is a reasonable time. But 10 years definitely is not a reasonable time. So in those cases, on those facts, on the ground of limitation, they have they have allowed the SSC's claim and they have dismissed revenues version. So there's one judgment of Madras High Court wherein the issue came, again, of course, it is related because DRI show cause notice are now been revived and there are many matters which are coming before Delhi High Court. It is pending. We as a firm, we are representing many clients for that. There the issue is the amendment which came on 29th March 2018 in section 28 clause 9, and the amendment was, in fact, there was a new section brought in, section 9A, which said wherever it is possible it goes. It only says 6 months and 1 year. So if this new section has come in, whether this new section will be applicable to the proceedings which were now in fact revived. So the Madras High Court has categorically held that if so far this amendment is concerned, because there is an explanation which categorically says that this will be applicable post, it's a prospective amendment. So all the old, all show cause notices which were issued prior to that date will be applicable by the old law. So meaning thereby we are again to square one. So if even when the new law 2018 has kicked in, the new procedure is there, but due to an explanation and nobody right now has challenged that explanation, will be governed by the old law. So old law specifically says wherever it is possible. So on the facts of every case, court has to be shown, it has to be demonstrated that whatever was there as an SSC, we have done. And then the department was sleeping over it and they have not done anything. So in that way, there is a vested right of SSC which has come after that period of limitation is over. So they cannot revive a proceeding which is already time barred in that sense. So I think this issue is alive, not only under CGST, but customs and various courts. Delhi High Court, Bombay High Court recently has decided this issue in favor of the SSC. They said you cannot revive after 10 years exactly DRI show cause notice. So the issue is alive. So that is what I thought I'll supplement. Now the second decision which we really want to talk about is KBT. So before I start with, why this is a split verdict. And as Mr. Kapoor started in the mentioned in the start itself, that generally in tax matters, you don't hear about split verdict. But so far this split verdict is concerned. In fact, while we were doing the matter in court, we were also, we're thinking, the kind of feelers which we got from court, it could be a split verdict. And in fact, when the pronouncement came, we proved ourselves to be right. So I'll just give a little background of the facts and then I'll come to the split verdict. So basically, KBT, as the name suggests, basically they were tea manufacturers. And this matter relates to West Bengal Finance Act. So under the West Bengal Finance Act 1941, the term manufacturer also included blending of tea, right? In 1994, West Bengal Finance Act was substituted and Sales Tax Act 1994 was brought in. Sales Tax 1994, there was an amendment and which included blending of goods. So blending of goods, the definition again in 1998 was blending of goods was there in 1998. And in 2001, the definition again was changed from blending of blending of tea remained. So during the intervening period, the West Bengal state came with a scheme for starting of small scale cottage industry, small scale industries. And they said people to come forward and start an industry, right? So what was the incentive which was given to the people who were setting up these plants? Incentive was that whenever you are procuring raw materials, that raw materials for the purpose of manufacturing of tea, that raw material will be exempt from sales tax. So that was a good enough incentive for people to come forward and have to set up a plant. So in this case, this was a group of almost 16-20 people who came forward and they set up a plant, they invested. And in fact, every SSC was able to show that how much money was invested and how much money they have spent in bringing out that plant. So what happened? In 2001, after 1998, this amendment was there, which included blending of tea also as a manufacturer. And in 1999, there was a scheme. In 2001, there was an amendment and this blending of tea word was omitted from the word manufacture. So meaning thereby, after 2001, this blending of tea per se will not amount to manufacture. Thereby, you will not get any incentive under that scheme. So the SSC here in this case had already enjoyed the exemption for 2 years, but he already had got an eligibility certificate for a period of 7 years. And whatever was required as per that scheme, that, this amount of capital expenditure, this amount of investments, All that he had satisfied, and that is the reason he had got an eligibility certificate for a period of 7 years. Now the question comes that he had enjoyed the exemption for a period of 2 years. For the balance period, he said that, look, it is only because of the allurement by the government that I have set up this plant, I have invested this money, and I have changed my position. That is, I have altered my position from X to X plus 1 or X plus Y. So of course, the matter was dismissed by the West Bengal Sales Tax Tribunal, by the High Court. The matter came up here in appeal before Supreme Court. So Supreme Court, there were many issues which you had read. Of course, we talked about the definition, suddenly changing the definition without there being any reason. There was no statement of object. There was no public policy. And we had a vested right also in claiming the benefit for the balance period. So Justice Shah, who was not in favor of the SSE, he said that you don't have a vested right, you have an existing right. And there is no question of any legitimate expectation, because there cannot be any legitimate expectation against the statute. So what you're asking, that the government could not have changed the definition, so that is not the correct way, because there is nothing legitimate against a statute. They could have always done it. If they have done it, you don't come within the 4 corners of the definition, you're out. So that was his view, right? And if you see the split verdict, Justice Murari has given a split verdict, and in fact, he has dealt with all the judgments of this legitimate expectation. Although he also said that he does agree with the point of Justice Shah that it is, so far vested right is concerned, he doesn't agree with the vested right, because according to him also, it is an existing right, and that is not a vested right with the SSE. But vis-a-vis legitimate expectations, he has laid down a lot of parameters, and he specifically dealt with MRF judgment, then Samuelson judgment, and he has come to a conclusion that, when a particular SSE is given that kind of an allurement by the state government, and they come forward and they set up, so there is, sort of an, if there is no incentive, there's no point for the SSC to come forward and set up those plants. Once they have changed the position, altered the position, then they have a legitimate expectation to at least think of getting the exemption for the balance period. So then, in fact, if you see in the last paragraph, Justice Murari has laid down certain principles. I'll quickly tell you that there are principles which had been laid down for the purposes of legitimate expectation. He has said that in scenario like this, and he is held in favor of the SSE. Scenario like this, legitimate expectation is something which can be expected by the SSE, and it is the duty of the government who has allured that particular SSE to change his position to give the benefit for the balance period. So this is all about this doctrine of legitimate expectation. I'll quickly tell you, run you through the pointers which has ultimately be given in the final judgment. So he said legitimate expectation also needs to be legitimate. So the findings and the pointers which he has culled out after taking care of all the judgments which is pronounced by Supreme Court, and in fact they have accepted our contention. He says expectation should be reasonable. It should be based on a clear representation. It should be made by authorized person. It should be legitimate. It should be demonstrated. It should not change. It should be not supersede the change in policy. So the entire crux of the matter is that when you are changing the position, you have to show that there is a public policy. In the present case, we were arguing that the government has not been able to show that what was the larger public policy that was changed, that was required to be, taken care of, and that is the reason that amendment has brought in. So the clear argument which came and which was accepted by the court was that the revenue has not been able to show that what was the larger public interest that was being hindered, and that had to be protected, and because of that, the change in law had to take place. So that is also one of the point which the court, while concluding, has said that public interest must supersede change in policy. The expectation must be based on legitimate interest, and the expectations must be protected. So I think this has got a far-reaching consequences, and any matter where similar kind of a situation is pending, because pre-GST, post-GST, we have seen the several matters which are pending before Himachal Pradesh High Court, where it's also pending before Nainital Uttarakhand High Court, where the fight is between that there is a state subsidy budget which is being allocated to the SSEs. There also the fight is there But of course, this judgment will also help them to at least put forward their point and at least convince the judge that if we have changed the position and things have happened like this, at least this should be given. So that is all about the legitimate expectation. Yeah.
Thank you. Kavita, to take us through the judgment of legitimate expectation on the
Excuse me, madam, some disturbing sound is coming from somewhere.
vested right, and also you have legitimate expectation. I think we should go through all this judgment because would be a difference between existing right, a vested right, and a promissory estoppel.
Okay. So I'll be happy to answer. See, basically, when you're talking about a vested right, so vested right is something, if you really in one line, if I can answer, it is something, it is not contingent. It is not dependent on something. It is absolute. You have a right and there is no contingency attached to it. So it is a vested right in that sense. And then when you're talking about promissory estoppel, I said the cord between promissory estoppel and legitimate expectation is one and the same. It has to run through the same cord. But the question is, promissory estoppel would come under the domain of private law, and legitimate expectation would come in the domain of public law. Once it is any law which is public and public are interested in that, then the public policy becomes foremost. And so any law which you want to change, so then, and it is affecting public at large, then that becomes a question which needs to be shown. So the concept of legitimate expectation comes. And so for promissory estoppel is concerned, we all are aware that there can be no promissory estoppel against a statute. So government, for the purposes of, again, for public policy and if a larger interest of the of people, they can always change. And now existing right, like for example, in this case itself, like since we had claimed exemption for 2 years, and as per the eligibility certificate, we had the right to claim for another 5 years. So that is an existing right and a continuing right. So that is how it is an existing right.
Yeah, thanks for clarifying that aspect. So I will take through the next.
I hope I was not very fast because I thought we have just 1 hour and there are 5 judgments. So we'll have to cover that. There'll be questions which we will be having. And I was not sure of this question coming from Mr. Kapoor, that he will interject and ask this question. So I'm happy that I'm answering. But at the same time, back of the mind, I'm thinking that I'll have questions from people. But anyways, it was a welcome question. So you're welcome. And then you wait for my turn. I'll also have one question reserved for you.
It's a tit for tat that
Kavita madam want to do.
No, I wasn't expecting. So since you have eaten out my time, I'll equally ask a question to you.
Sure. Thank you. Thank you even for answering that aspect. Existing right vis-a-vis vested right and promissory estoppel. Though, friends, there are judgments from Supreme Court on this aspect of promissory estoppel, starting as old as Purnima Oil Mills and Southern Petrochemicals, wherein Supreme Court has come clearly on that there is a promissory estoppel against the statute as well. Having said that, this judgment deals only on the aspect of legitimate expectation vis-a-vis vested right, which was argued by both of us before Honorable Supreme Court. And here is the judgment, and we hope that the judgment pronounced by Honorable Justice Murari stands before the larger bench, and it will have a wider implication, as has already been stated by my colleague Kavita, because you have a state budgetary support which was given to industries at large in post-GST scenario, who had set up companies or industries in a pre-GST era. So therefore, this aspect of legitimate expectation would definitely have a large bearing on all the matters which are pending at various levels, at various high courts across India. Now with this, friends, I would like to move on to the other next judgment. International Travel House. The cause title do read as Commissioner of Commercial Taxes, Delhi versus International Travel House. I'll just give a brief background. this matter, initially there was a Delhi Sales Tax on Right to Use Goods Act, which was enacted in 2004. Our client, International Travel House, had entered into a contract with NDPL for supply of certain cars to them on 24/7 basis. But the terms and conditions of the contract were clear that the car will go out in the morning and come back at night, and the effective control of the car will always lie with the chauffeur. NDPL said that they would only say that it is a service, it is not a deemed sale, and therefore a representation was filed. The matter then traveled to tribunal. Tribunal gave a favorable order holding it to be as service. The department challenged it by way of appeal to High Court. High Court also held the same as services, holding that there is no effective control transferred. So what they said, that you have to understand that the meaning is transfer of property and goods on right to use basis. Therefore, you have to first take care of the word transfer, which means alienation of right by one and enjoyment of right by the other. Having said that, since there is only a mere possession of the vehicle given to the person or the company, therefore it cannot be held to be a case of deemed sale. And rightly so, they said Article 366(29)(a), which was amended in 1982, which widened the definition of the term sale, included the term deemed sale, and which also had transfer of property and goods on right to use basis. In this present case, has been held to be only a service. The matter then traveled to Supreme Court. Honorable Supreme Court also, after going through the matter at length, held that in the present case, in the present facts of the case, since it is only mere possession and there is no transfer simpliciter, therefore it cannot be held to be a case of deemed sale and therefore only liable to service tax. However, reliance was also placed on the judgment of Honorable Supreme Court 5 judge in the case of Bharat Sanchar Nigam Limited, which actually propounded 5 governing principles, and also Rashtriya Ispat Nigam Limited, which also is a Supreme Court judgment, which again said that there has to be a clear line drawn between deemed sale and a service. And on that, I would like my colleague Swati Agarwal to take us through those 5 principles, which was laid down by Justice Lakshmanan in its concurrent judgment in the case of Bharat Sanchar Nigam Limited. So Swati, if you can just take us through those 5 principles laid down by.
So to constitute a transaction for a transfer of the right to use the goods, the transaction must have the following attributes. There must be goods available for delivery. There must be a consensus item as to the identity of the goods. The transferee should have a legal right to use the goods consequently, and all legal consequences of such use, including any permissions or licenses required, therefore should be available to the transferee. For the period during which transferee has such legal right, it has to be the exclusion to the transferor. This is the necessary requirement. Having transferred the right to use the goods during the period for which it is to be transferred, the owner cannot again transfer the same rights to others.
So we basically fit in which clauses?
We actually fitted in almost all the 5 clauses, but the last clause, that it has to be to the exclusion to the transferee. That never happened because the cars were coming out of the garage in the morning and going back, and the effective control was always with the driver of International Travel House. And the licenses, all the licenses were in the name of International Travel House. Now, for transferring the car on lease to another, the license also has to be necessarily transferred. And therefore, Justice Lakshmanan very categorically held that these 5 principles are non-concomitant in relation to deciding a fact, whether it is a transaction for transfer of property and goods on right to use basis, or it is only a mere right to use or possession of such goods, which would be only liable to service tax simpliciter and not deemed sale. So these were the crux of this judgment. I think these matters are still live at various high courts in the state of Telangana, state of Andhra Pradesh, state of Karnataka. So we thought it proper to just bring this aspect also to life.
However, in GST aspect, it's very clear that if a company who is into business of leasing or is giving car on rent, if they are not claiming any input tax credit, then the rate is only 5%. However, if it is not, they are claiming input tax credit, then the rate is 18% and they can claim their input tax credit. But this is only in a pre-GST era where these matters are pending at various high courts. So we thought it proper to bring it to the notice of all our audience and participants, which is of eminence to some of the companies.
I had reserved one question, so I am taking the liberty to ask.
Yes, please.
So is the concept of composite contract still in existence? Can we still use it as an argument before the court?
See, composite contract and dominant intent test was very well laid by Honorable Justice Ruma Pal, again in the case of Bharat Sanchar Nigam Limited. And it has been held in this judgment that composite contract vis-a-vis works contract, the dominant intent may not lie today. But with respect to transfer of property and goods on right use basis, the composite contract may have two elements, one for goods and other for services, but you can't break that composite contract. So therefore, they said that irrespective of all that, still you have to only decide whether the dominant intent would lie as a transfer of property and goods on right use basis or it is a service simpliciter. So therefore, they relied upon this judgment of Bharat Sanchar Nigam Limited and the principles laid down by Justice Lakshmanan and also by Justice Rumapal on the dominant intent. However, today the dominant intent test is only maybe applicable to the transfer of property and goods on right use basis, but with respect to the works contract, it is not applicable because L&T and Kone Elevators have dealt otherwise, the test of dominance. I hope I've answered this question.
Yeah, you have answered. Thank you. This reminds me of one example I'm just giving, because you rightly said it is not applicable in works contract anymore. But there was one person, X, all right? That person went to a parlor and that person wanted a fitment of a wig, right? So the question which came before the court was, because she or I should say, he actually it was she, it was he, not she. So he went to the parlor and he wanted a fitment of a wig. So the question which came before the court, so did he go for a service? Did he wanted to buy a wig, or he wanted only to go and take that services of fitment of wig? So the question which came before Karnataka High Court or Madras High Court, that is it a service or a sale? So will it amount to a sale of a wig or service? Because if you buy a wig, you're going to a parlor to buy a wig for a fitment, then this should be basically a service. So here the dominant intention was used. In fact, it's the very latest decision. And the court concluded that situation like this, you still have to use the dominant intent. So the intent was not to go and buy a wig from a parlor. The intent was to go and, go for a fitment of that particular wig. So that is service. So applying this law of dominant intent, it was held to be a service tax.
Just to add in that case, actually what had happened, because when this company was manufacturing wigs and therefore they were paying VAT and they were also paying service tax while affecting the sale. Now the question what Kavita ma'am had asked with respect to when a person goes to a parlor. So obviously, a wig, basically it is more of a service because he is basically trying to put that wig on his head. And therefore, as rightly held by Karnataka High Court in this case. This is a very recent case, but again, it has to be tested. Because if you see other judgments with relation to where it has composite nature, where you have a transfer of goods, sale of goods, and also services, applicability of dominant intent has been held to be otherwise again by Supreme Court in L&T and Kone Elevators. Though it needs to be seen if this matter travels to Supreme Court and it goes to a larger bench and the larger bench decides this issue. Of course, I am in favor that the dominant intent nature test should be applicable in all cases. But in works contract that we were referring to a recent matter which we're doing before Delhi High Court, there also this question came. On the aspect of works contract, and there it was, again, it was held by Delhi High Court. It's still sub judice, but they had formed their view and they said that this needs to be seen whether providing of lights by the company will, along with certain services, where services are just minuscule,
whether it will tantamount to a sale of good or will it be a service. So there we were actually arguing the other way around. We said it's a case of a sale of goods and not a service. With these questions, are still pending at various levels in High Court and requires, adjudication by various High Courts and Supreme Court, especially on the aspect of dominant nature test, which is still to be adjudicated finally pursuant to this recent judgment of Honorable Karnataka High Court and Madras High Court.
I think so. What Mr. Kapoor was saying, that depending on the facts of the case, he's going to change his hat and change his arguments too. So it will all depend on the facts and your brief.
So next judgment, I would request my colleague, the Ecom Coffee Gill. This judgment of Honorable Supreme Court also is of eminence as onus of proof or burden of proof, as you may call it, has been cast upon the assessee who is claiming input tax credit, and as also rightly held by many, it's quite onerous to prove, because even though rules are set in, there is section 16, there is section 155 of the GST Act, which has dealt as to what are the provisions or specific aspects that need to be taken care with respect to the transaction while claiming input tax credit. This judgment only actually dealt with one aspect, that is a Quest merchandise. That also had arisen from Delhi High Court, which traveled to Supreme Court. I don't know, they did not really consider Arise India. So if I were to see, then Arise India is today in my favor. And therefore, since it has not been written by Supreme Court, therefore Arise India Supreme Court will still hold good. Vis-a-vis also will run parallel to this Ecom Coffee Gill matter. So over to my colleague Kavita to take us through this judgment.
Thank you. I think in the first blush, when you read the judgment, you will feel that it's very harsh, because that the burden of proof per se, when it's like as if you are undergoing a criminal trial, because the words used are, you have to prove beyond doubt that since you are the person who's claiming ITC, it's a genuine transaction. So if you really see in this particular matter, section 17 of Karnataka VAT Act has been dealt with, and Karnataka VAT Act section 70 talks about burden of proof. So burden of proof, as a dealer, I said I've shown the invoices and I have shown that payment, how the payment has come, right? Those two things, initial thing, and after this, I said burden shifts to revenue. Now, but revenue has to show that this transaction is not genuine. So initially, the assessing officer doubted the transaction and said that you have not been able to show the transaction is genuine. So the court has gone one step ahead and said that it is your duty, it is your burden cast, despite it is not specifically there in the section. They said you have to show all the elements beyond doubt that the transaction is genuine. In fact, if paragraph 9.1 of the judgment specifically says that what is the reasonable thing you have to do as a dealer to show that the transaction is genuine. He said that to prove that the transaction is genuine and it is actual, not only furnishing of name and address of the selling dealer is important, you have to show the vehicle which has delivered the goods, you have to show the payment of freight charges, you have to show the acknowledgement of taking delivery of goods, you have to show tax invoices and payment particulars. So all these details are there in the judgment itself, which says if you are asking for an input tax credit, then you are the one who has to show that the transaction is genuine. Merely producing invoice, merely producing that payment is through banking channels, the burden does not shift to the revenue. So I think this is quite an onerous judgment, and every matter where SSC is claiming, a dealer is claiming an ITC, this will be looked upon by the assessing officer, and it will be these are the documents which now the SSCs have to actually procure to show that the transactions are genuine. So according to me, it's a very harsh judgment.
So two aspects apart from what Kavita has stated, two additional burden which has been cast apart from the 6 other burdens which are part of section 155 read with section 16, is that you will have to now also show that you have made payment towards the freight charges. There is an acknowledgement of delivery of such goods. Apart from the other, that name of your seller should be there, name of purchaser should be there, delivery of goods has to be there, e-way bill has to be produced at the time. This judgment under the Karnataka VAT Act under Section 70, so as to say, was actually rendered under the three aspects where the assessee had claimed input tax credit, but the assessing authority doubted the genuineness of the transaction on the basis that either the company from whom they had taken the goods were filing nil returns, or they were actually they had deregistered themselves. And the third that happened, actually, they stated that no transaction per se happened between company A and company B. So, in light of those three aspects, Section 70 came in. Burden of proof was cast upon the company who was, or the assessee who was claiming input tax credit, and therefore this matter traveled to Supreme Court. And Supreme Court very categorically held that irrespective, the burden cannot be cast upon the authorities. It is the assessee at large who is claiming this benefit of input tax credit. He has to come out clean and to show that transaction is clean. And friends, you are aware that even in GST there is so much of fake invoicing and other aspects which are taking place in the last 6 years. And therefore, this judgment of Honorable Supreme Court actually is of importance to all. And apart from whatever steps are being taken by the assessees who are claiming input tax credit, I think you need to be more stringent, you need to be more active in relation to seeing that the transaction is not fake, it is genuine, so as to claim the benefit of input tax credit in your returns. With that, I think the last judgment that we would like to take you through is the judgment of Honorable Supreme Court, which is again a very recent judgment, has a wide implication on the aspect of warranties. Is the case of Tata Motors Limited versus Deputy Commissioner of Commercial Taxes. This judgment, in my view, has a far-reaching impact in a post-GST scenario. Though this was held in a pre-GST or a sales tax scenario, where the issue came in whether credit notes can, if there is a transaction happening between, say, Tata Motors, who had delivered the car to me, and I, as part of the package, also take a warranty, extended warranty or warranty for a period of 3 to 5 years, and I pay an extra amount to Tata Motors or to the dealers. In the event the car breaks down, what can be the implication? So if I have to take a car to a Tata Motor division itself, and the repair has to be undertaken by Tata Motors, then in that case, there is no liability of GST, or there is no liability of a pre-GST tax or VAT or service tax in that case. However, the transaction would differ if, suppose, a distributor of Tata Motors, say I stay in Noida and I buy a car from Noida and the car breaks down, and I take my car for repair to Noida distributor, and he does not have the part. So two things can happen. Either he will buy a part from outside, and then a credit note has to be issued by Tata Motor to the distributor of of this company, Tata Motor. Or the second case would be that Tata Motor may even ship those goods to the distributor. In that event, also there is an issue while dealing with the judgment. I think Justice Joseph came out heavily that in this kind of a transaction, irrespective, there would still be a credit note would be issued. One, if goods are supplied directly by Tata Motor to the distributor, then only in relation to a service part. However, on the other category, if the goods are used by such distributor on his own account and services are also provided, then the credit note so issued by Tata Motors would have two elements: one with respect to the goods, and the second with respect to the services. The third category that would fall as per our understanding is, suppose I am driving down to Shimla and the car breaks down in between, and then I have to go to a mechanic who actually is also a kind of a extended distributor of Tata Motors. He has the part with him. So in that case also, a credit note would be issued by Tata Motors to such mechanic or to the such service station. The larger issue that came out, whether this credit notes so issued by Tata Motor can be subjected to tax. Supreme Court categorically held that credit notes also has a somewhat consideration stated, and therefore, in their view, while upholding the earlier judgment in the case of Muhammad Ikram, Falabad High Court and Supreme Court, the matter was then referred to a larger bench of 3 judges. In this case, then they said, yes, even the credit notes would be subjected to tax. And therefore, this aspect that the credit notes would also be subjected to tax in the transaction as stated as an example, second and third, not in the first case, but second and third. Therefore, the credit notes would be amenable to GST also, or would be amenable to a pre-GST scenario. So these were the facts of the case, which I think it is important that even in a pre-GST scenario, this judgment will hold good, and the companies will have to take a stand that while issuing credit note to the distributors or to the extended distributor, will have to charge tax in relation to such issuance of a credit note. With that, I think I will leave it to my friend Kavita if she has any question, or maybe Swati if you want to take us through.
No, I think this issue is definitely going to have ramification for all those who are, having this warranty obligation, because this warranty obligation is arising out of an agreement. And if one sees this judgment, in fact, the honorable judge has dealt with the Contract Act so minutely, every provision of that, and then come to a conclusion that this, when you're talking about this credit bill, so this credit note is per se, it's for a valuable consideration. If it is for a valuable consideration, then tax is leviable. But I think it will have a larger implications, and it will have an industry-wide application for all those who are having currently the warranty obligation.
So warranty obligation in any case is everywhere.
Yeah, that's right.
Be it, you buy a fridge, or you go, take services of a company like Thyssen, who is installing a lift, or a laptop, or any commodity that you are buying, which has warranties inbuilt into it.
Thank you, Mr. Kapoor and Ms. Jha, for briefly explaining the integrities of the recent landmark rulings of High Court and Supreme Court. We have already received few questions from the participant. The first question is from Mr. Akash. Is there any time frame within which a show cause notice should be adjudicated?
Can I take this? Yeah.
Sure.
So basically, when we were dealing with this judgment of Nanuram, so we were dealing with Section 73. So when you see Section 73, this section, the new Section 73 Clause 4 and 4A, that was inserted with effect from 1st April 2014. So 1st April 2014, that gave a time limit, that 6 months or 1 year. So prior to that, there was no time limit per se. Again, under the Customs Act, when we are seeing 29A, 29 other provisions, we are seeing there also the provision came in, but in 2018. So prior to that, there was no time period per se. That is the reason, if you are seeing, we are seeing cases from the DRI, from the CGST, that they are reviving old cases which are pending with them, maybe on the pretext of call book, or maybe the pretext of anything else, but they are now reviving. But when you're talking about time limit per se, yes, now it is there, but it wasn't there in 2010, 2011 per se, like 6 months or 1 year. Then it is a reasonable time which has to be read into for those matters, those cases.
Just to add
what my colleague has said, under the Customs Act, there was an amendment made. But that amendment came after the judgment of Honorable Punjab Haryana High Court in the case of Harkaram Singh. And actually, if you see that judgment, then the implication is post 2018, whereas the courts today are reading even pre 2018. So therefore, I think there needs to be some kind of a clarity that needs to come from the courts.
So Madras High Court, which I was mentioning, is with respect to this only.
Correct.
So yeah.
Next question is it legally valid to transfer matters to call book and keep pending for a longer period of time? Mr. Kapoor?
Yeah, I'll take it.
Yeah.
See, this question was also dealt in detail in Nanuram Goyal in Delhi High Court. There is a CBIC circular which is already in place. It's actually an internal thing by the department, whether to keep a adjudication in call book or not. It is up to them. So they have a committee of commissioners who take that call, whether the matter has to be taken up in a call book or not. Legally or not legally, we don't know, but frankly, it is under the CBIC circular, therefore they are within their reach. But having said that, the matter is still subject before Supreme Court on the aspect of call book, and we will have to wait for the orders by the Supreme Court in this aspect.
So typically, the procedure of transferring the matters in a call book is not backed by any statute or any section. It is just an internal circular. It's an internal arrangement between the departments to keep the matter pending to await a decision in some other matter. But the procedure per se, whether this procedure of sending the matter or transferring the matter in call book, that is there in this Riddhi Vinay, which is pending before Supreme Court. So all of us are arguing that there is no such procedure. It is not backed by law. You cannot do that. You cannot revive it. And even if you are transferring, it is your duty. Revenue is duty bound to inform the SSC. How will SSC know that my matter has been sent to a call book? And suddenly after 10 years, when you wake up, you send me a revival notice. That is what cannot be done. So that is what we are harping. That is what we are using.
In fact, categorically, Justice Bakru very categorically said that it's an abuse of power by the department whenever they are putting these matters in a call book. It's like an harassment to the assessees at large. Yeah.
In fact, I'll share an interesting thing which happened in the court. So the department counsel, both of us are there. So we were doing the matter. So the department counsel, he asked very politely, so what do people do? He said, we revive, we see the matter, we take out from the call book after 5 years. We see the matter, we again send it to the call book, and then again we revive and then again send it. So he was jokingly asked, so what is the procedure? You take it, you send it, you take it, you send it. So ultimately, what do? He said, it is how it is. This is how we deal it with the call book.
Just to add, this funny aspect that that happened in the court, in this specific cases that we are dealing, almost 10 times the matter was put in a call book and then retrieved and then again put. So therefore, the honorable justices were really laughing at them, how they are taking care of these matters, which has wide ramification of revenue. The present matter that we were dealing almost 100 crore plus.
That's right.
So therefore, I think it is important that this judgment of Honorable Supreme Court comes out clearly on the aspect of call book. Though according to us, irrespective of the procedure, maybe it is all internal, and therefore no notice is sent to the companies at large. Yeah, thank you.
I hope, Sandeep, we have been able to answer the question. Whoever has raised the question, we have been able to satisfy.
Yes, ma'am, completely. The next question, what is dominant intention test? On what transaction it is applicable? Is it still valid?
I'll take it. So this has already been answered, I think, during our conversation of this webinar. The dominant intent test was laid down by Honorable Justice Rumapal in the case of Bharat Sanchar Nigam Limited. Having said that, today, as Kavita ma'am also discussed, that dominant intent test is in the case of that WIG matter, which is Karnataka High Court, and also there's one Madras High Court on this aspect. That dominant intent test, though, has been overruled by L&T and Kone Elevators, but that is only in relation to a case of works contract. But with respect to transfer of goods on right use basis, according to us, it is still live. And therefore, in the cases where there is a composite contract, like the one we talked about, International Travel House, where there was service and there was an element of transfer of goods, which was car in this case, the courts came out very categorically, taking into the facts of each case, what would be the dominant intent. And there they categorically held that the dominant intent in the case, what we referred to during our conversation last, was that it's a case of service simpliciter and not a case of transfer of property and goods on right use basis. So therefore, in today's situation also, depending upon fact of each case, it is important that you need to decide what would be the dominant intent.
That's right.
Yeah.
So do you think it will make a difference if the contract per se is severable and there can be a split between the contract? Will it make any difference? Sorry, yeah. Will it make any difference if the contract is divisible and it's separable? The dominant intent, will it still lie? I think, Sandeep,
So basically, dominant has already been held by BSNL case and overruled by the Larsen L&T case. Dominant intention test is no more applicable with respect to works contract matters. As we've already discussed, it is applicable for all other matters where where portion of service and goods are being transferred. So one has to see that what was the intention of the buyer, or whether to take the service or whether to take the goods. As we have already discussed that while going to a parlor and getting a wig being implanted, so in that case, the dominant intention was to take the services of the parlor and not to buy wig. So in that case, the service tax is leviable. So I think the point is very well clear that dominant intention test, as on date, is not applicable with respect to works contract. However, for other contracts where both service and goods are being transferred, it is still valid.
So we can't give a complete go by to a dominant intent, and depending on facts, if need arises, we can always use this right as an argument to show that what exactly is the intention of the parties.
Right.
Thanks.
But I think your question was
If it is separable, yeah.
If it's separable.
Yeah.
So if it is already, there are two ways of looking at it. One is separable by fiction of law, or if you already have a separate contract, say one contract for only supply of goods and other for supply of services, then in any case, for supply of services would be service tax, and supply of goods would be entailed as taxable under VAT or GST. So therefore, in that case, there would not be any dominant intent test applicable. This would only be applicable if it's a composite contract
And not separable.
and not separable, even by fiction of law. Therefore, therefore, you'll have to get into that aspect. What would be the dominant intent in the matter? I hope I'm clear.
Yeah, sure. Sandeep, you want to add something?
Even in post GST, it will lose its reference because it is applicable more with respect to earlier laws. Now everything is either a service or a goods. So there is no debate basically whether it is a goods or a service. It's all either say goods or a service as defined under the schedule. So we have to pay tax according to it.
So even if it is a composite contract, if it is not separable, then also we have to go by this formula. Am I right in my thinking?
Yeah.
Yes, ma'am.
Yeah. Okay. Thanks. Thank you. Any further questions here?
Yeah, we have some more questions.
Okay.
Since section 155 of the CGST Act is perimeter to section 70 of KVAT Act, what will be the impact of judgment on taxpayer under GST? Kavita, would you like to take?
Yeah, I think, see, so far the e-com grill, which we were talking about, that talks about section 70 under the Karnataka VAT Act. But section 155, the section per se says, I think that requires about 3 or 4 things or 5 things. As a burden of proof, it is perimeter provision. So if you see, there are 2 more things which have been, as per the judgment, which has to be shown by the dealer before claiming ITC, is I think freight charges, and also the delivery of goods have actually happened. That has happened, that has come to you. So the burden
details.
Yeah, is the details. I think it's now more onerous.
Yes.
It is now that it's you have to prove beyond reasonable doubt that transaction is actually genuine. Merely producing invoice and the payment details is not sufficient.
Under the GST Act, they have covered everything. See, section 16 talks about that you have to showcase the actual delivery of the goods. You have to make the payment within 180 days, otherwise you have to reverse the credit.
But Sandeep, I think most fake invoices cases when we are hearing is in the cases of GST only.
Yes.
So the maximum matters where we are doing matters is fake invoices under the which is there in the GST. So I think more stricter law, more loopholes people bring in.
Yes, ma'am.
Yeah. But yes, of course, it will have a ramification because now there is a judgment. So those assessing officer will not only look to the lens of the sections per se, but also something which is not there in the section, they will also look for, they'll call for, they'll ask the SSCs. So SSCs now have to do their homework much, much better prior to this particular judgment coming into effect.
In fact, tomorrow they even may ask for a CCTV footage of whether the goods have been delivered at your warehouse or not. They can go to any extent. This judgment gives a wide power to the assessing authority with respect to, giving benefit of input tax credit. He may reject on any count. And therefore, this judgment is of immense importance to all companies and individuals at large who are registered under the provisions of GST Act.
Yeah, this will have a wide ramification. Yes, that's right.
Because the burden of proof is on the taxpayer who is claiming ITC.
That's
so
right.
They can ask for anything.
It's no more he who alleges has to prove that concept is gone. He who claims has to prove beyond reasonable doubt that yes, this is a genuine transaction.
Yes. Yeah, one last question we'll take up. This is, can section 155 override section 16(2) of CGST Act?
Mr. Kapoor can
Sir, you
answer.
want to take this?
Yeah.
I think these are separate provisions. Section 155 is pari material to Section 70 of the KVAT Act. Section 155 is under the GST Act that has prescribed what are the points to be taken while claiming input tax credit, coupled with Section 16. Both are running parallel. However, this needs to be tested whether it will have any overriding effect. Section 155 would have any overriding effect on Section 16. Which according to me should not, but it still needs to be tested in the courts of law.
Yeah. Thank you, Mr. Kapoor and Kavita ma'am for
Thank
the
you.
wonderful
Thank you so
session.
much.
We have received few more questions, but due to paucity of time, we will be sending our responses over email. We hope to come back with more seminars on legal issues. Please do let us know what your feedback with respect to the webinar. We look forward for them. Thank you.
Thank you so much,
Thank you.
everyone.
Thank you so much. Thanks. It was pleasure interacting, and we look forward for many more webinars like this. Thank you so much. Thanks.